you have boundaries and you know where your knowledge ends. So just because you did, I did a Caesar in 2009, 2008 in Mansa. And then today, the court asks me when I'm in court about issues to do with cesarean section. My answer is basic and simple. My obstetrics and gynecology is very basic and it cannot be used by this court because it will be misleading to this court. And so if a court may wish, they may call an obstetrician to give an opinion about obstetric issues. Now, that is not to say that, and I say this because I want to clarify, when most of you, especially those of you who are in the rural area, will be called to do a postmortem examination. You cannot, when you've done the postmortem examination yourself, you can then not say, I cannot answer to the cause of death because that's for the forensic pathologist. No, because you've done the postmortem. You are deemed a competent person to conduct that examination. My point here is we cannot, when you're asked a question that is outside that postmortem, but connects that postmortem and it is specialized knowledge, you must acknowledge that. So it's very clear. If prompted to speculate, your answer is very clear. Your answer is very clear. You tell the court that your evidence does not support that conclusion. If you are provoked, and sometimes they do provoke you. So there are many times when I've been asked a question, have you ever lied before? So you're in court and the next question is, have you ever lied before? And your reaction to that is always, when you're provoked, pause, breathe, and then return to your findings. Talk about your findings. If you are pressed into a yes or no answer, make sure that you tell the court that a yes and no answer will not provide meaning to the court. So you cannot answer yes or no. And I must say that as a witness, when you are being cross-examined, when the answer requires a yes and no, it is yes or no. But there are questions that are asked that require explanation. And so you must say a yes or no answer will mislead the court. That way, then your lawyer or the lawyer that has called you will ask you that very question to explain in re-examination. The next thing I'll talk about is demeanor. So your composure communicates the stability of your reasoning and testimony. So you must be upright, still posture. The judge will interpret that as cognitive control. When you are slow and deliberate in speech, the judge will interpret that as reasoned judgment. Looking at the judge as you speak allows the judge to correct the audience orientation. And then pausing before answering makes the judge feel that you are thinking before you proceed to speaking. This is not performance. This is professional reasoning, self-regulation made visible. So when cross-examination is done, then the lawyer that called you will then come back and do what we call a re-examination. And in re-examination restores clarity if the cross-examination introduced confusion in your evidence or in your testimony. Right? So re-examination restores clarity if cross-examination introduced confusion, not to argue, not to reinforce certainty, not to restate everything, but simply to correct and re-anchor the reasoning chain that you used. An example would be, if you're asked or in re-examination, you say, to clarify, I described the findings and the mechanism most consistent with them. I did not make any statement regarding responsibility. This signals intellectual control and integrity. In closing, What the court evaluates is not what you know as a doctor in court, but how you know it, the methods that you used, and whether you can show that reasoning under challenge. Remember, bad ideas not stand up to scrutiny. So courtroom communication for clinicians is reasoning made visible. It is structured, it is calm. Again, your authority, as we end, your authority gets you heard. Your reasoning keeps you believed in court. Thank you very much.
Thank you very much, Dr. Mucheleng'anga, for that well-detailed and elaborate presentation. At this point in time, ladies and gentlemen, allow me to welcome the Zambia Medical Association Legal Counsel, Madam Elizabeth Chanda. Madam Elizabeth Chanda, are you on the call?
Yes, I am. Thank you, and good evening, everyone.
Okay. Good evening. I hope the network now is doing justice to you.
The network, I think, has made me run around. I hope I'm clear enough. I'm actually sitting in the car, but at least I've managed to join. So I hope I'm clear.
Okay. Thank you very much. So, Madam Elizabeth Chanda will share with us some of the expectations from some of the expectations of a medical witness from a lawyer's point of view. So, Madam Elizabeth Chanda, maybe before you get into maybe what you have to share with us, this meeting is being attended by 291 of the Zambia Medical Association members. So maybe at this point, I know it's a bit difficult. If you can turn on your video so that at least people just get to see who you are, at least they know you. I believe quite a number of times there are situations where your services are required. I think it's important that they know who they are speaking to whenever they are found in a situation where they need representation. So over to you, Madam Chanda.
Thank you so much. Okay, I'll switch on my video. I hope people will be able to see me or see just a black. My apologies, as I said, I'm in the car. I couldn't get home in good time because I was caught up in traffic. So I just had to find somewhere to park because of this meeting that we were having at 18 hours. So I'm really sorry. I would have loved to switch on so that people are able to see me completely, but this is the best I can do for now.
Thank you very much, Counsel, and we really appreciate it. Thank you.
Okay, thank you so much. Okay, so I was requested to speak about what the lawyer expects from a doctor who has been called to be a witness. But I think I would want to utilize the heading that has been used, I think. Hello? Hello?
Hello. You can go ahead, Counsel. Oh, Dr. Stanika, kindly mute yourself.
Okay. I was going to say that I'm going to utilize the title that was used for this particular program, which was effective communication. And I think that is basically what being a witness as a doctor is all about. And I think that the first speaker did endeavor to try and take us through the different stages that are involved. Being a witness is really basically about understanding the trial process.
What reasoning?
Okay?
Will make you believe, will keep you believed.
Sorry,
There's a mic.
Dr. Mucheleng'anga, kindly just mute.
I think what's to mute everyone does.
I don't know why they don't do it.
Hello, can you hear me now?
I'll keep you posted. Nice.
Yes, you can. Please go ahead.
Though the mics, I think, are still on, I can still get the feedback. Yeah, so I was saying that it's really all about effective communication. And I know Dr. Mucheleng'anga said that you must understand the case, but I wouldn't want, for me as a lawyer, I will not want to burden my witness so much as for them to understand the case, because that is the role of the lawyer. Your role as a witness is to understand why you have been called to be a witness. Yeah. So understanding the case is not that you have to understand every little detail about the case, but you must understand why I'm calling you to be my witness. And usually for the doctors, it's basically because I know that the initial discussion that was there related to murder, but there'll be so many other areas that you can be called. Sometimes it can be rape, sometimes it can be theft, sometimes it could even be where you were just an eyewitness as a doctor when a particular incident was actually happening. So you'll be called. So it is important, as I think the first speaker mentioned, that whoever, whether it's the prosecutor or the state counsel or whoever it is, they must be able to guide you and make you understand, why are you being called a witness? Is it because you prepared the medical report for somebody who was raped? Is it because you did maybe an assessment of somebody who was assaulted? Is it because you were a witness? Because when you go into court as a witness, the court will be looking out for you to speak to that particular issue. If you did a medical report, they'll want you to stick to what it is that you did in that medical report. If it is rape, when you are being asked questions, as I think the first speaker was saying, that the first stage will be cross-examination. And to avoid using jargon, I would usually like to say that, when you're talking about cross-examination, you are basically telling the court the story, what happened. And that is why at this stage, lawyers, which we learned at school, will ask open-ended questions, because as a lawyer, I'm not supposed to be giving evidence. Mine is just to ask questions. You are the one who's talking, okay? So at this stage, if assuming you prepared a medical report where somebody was raped, for example, your story will be on such and such a day, and this particular time, so and so, came, or I was working, I was the one on duty, and you explain what you did. And of course, when you are talking, the lawyer will be guiding you. They'll be asking the question, so what happened? So what did you do? So stick to your medical report. I always tell my clients that don't talk about things that you did not do. Try as much as possible to stick to what you did, because it becomes easier for you to answer. Okay, it becomes easier, and because the other lawyers, as the other presenter was saying, are listening, so that they can come and shoot you down on cross-examination. So when you are giving your story, yours is not to defend or accuse anybody. No, you are merely giving a medical opinion to assist the court make a finding of fact on technical issues. So you are not the one on trial. So there is no need to be apprehensive. It is your work. You did the report in the course of your work. So you are the best person who knows what you did and why you did it. If there are certain practices, there are certain protocols you needed to follow, there is no harm in explaining, I did this because in standard medical practice, this is what we do. So you are merely guiding the court. So don't become apprehensive because you are thinking, maybe if I say this, my lawyer won't be happy. No, if that is what you did, and usually it is what is on your report that you have prepared as a doctor, that is what you stick to in cross-examination. The lawyer knows the case, they will guide you on the questions that they will ask, and even what you should answer. So to avoid putting yourself in the spotlight, stick to what you did. If there is a medical report that is before you, stick to the medical report and explain what and why and how you finally arrived at your conclusion. Okay? The second part, I think that the first presenter talked about was the issue to do with cross-examination. And I know he did mention that it's adversarial. Now, when he uses that word, he's actually correct. But when it's adversarial, it's not about you per se. The adversarial is between the two lawyers. You are merely going to be attacked because you are the one who is supporting these people, not really supporting, but giving evidence that is helping these other people make their case. So the other lawyer, when you are giving your answers in cross-examination, their role when you are giving your information in examination in chief, when they are coming to cross-examination, their role is really to try and weaken your evidence, because they are also fighting to ensure that their client is not put in jail. So I'll just give an example. You can be called because you are an expert, because you've specialized in a particular area, a medical area. Sometimes you can just be a general practitioner, but because on this particular day you were the one on duty, you examine this person, and because you are the one that examined, you are called to go and be a witness. So the other lawyer will capitalize that on that already and say, so you are a general practitioner, so you haven't specialized. So because of that, sometimes as a doctor, you might feel antagonized, or you might feel that the person is trying to attack you. They are not trying to attack you as a person. They are merely trying to discredit your evidence. If they do say that, don't try to argue to try and demonstrate that, no, I'm an expert. Just to say that I'm a general practitioner, full stop. Your lawyer is listening. I think the earlier presenter talked about re-examination. Your lawyer is listening, and your lawyer knows that obviously you would want to explain why you are not an expert. But the best, I always tell my clients, don't argue with the defense lawyer, because if you do that, they are going to antagonize you. If you start arguing to say I'm an expert, they'll put you on the spotlight. So the best, if they say you are not an expert, if you know you haven't specialized, just say, no, I'm not. Your lawyer would have picked that. When it's now time for re-examination, they'll ask you, you were asked that you are, whether you are an expert or not, and you said no. Is there anything you would want to add? At that point, you will have your opportunity to explain yourself why you were saying you are not an expert. So the best way to avoid clashing with lawyers, just stick to the questions and answer. Usually when it's an examination in chief, you are allowed to talk, because there you are telling the story. What happened? What did you do? Why did you do it? Why did you arrive at a particular conclusion? When you go to cross-examination, the best I always tell my clients, stick to yes or no. They ask you a question, just say yes. They ask you a question, just say no. There are some lawyers who are nice, they will allow you to explain. Some lawyers, the moment to stay because they are on you. And when they do that, because you are just a doctor, you become apprehensive. And you are going to forget whatever it is that you wanted to say. So for me, I would usually advise my clients, just stick to the yes or no. The lawyer who has called you will be listening, and they know where you need to explain and where you do not need, because it may not be everything that is relevant for you to explain, but your lawyer would have jotted down. So when it's re-examination, they'll take you back. You were asked this. Do you have anything you would want to add? Then you can explain. So really, I think to be able to enjoy cross-examination, a trial, best is to know, when am I able to explain? When am I able to answer long answers? When do I just say yes or no? You are better off sticking to that, because then lawyers, if you find lawyers that really, there are some lawyers who would want to antagonize, and because they know when they antagonize you, you become apprehensive, you forget what you wanted to say. So just avoid. For cross-examination, for me, I'll always say, stick to the yes or no. Your lawyer is listening. Any lawyer who is representing you should be able to know that here my client or my witness is supposed to explain, and they should be able to ask you that in re-examination. Okay? So I think for me, in a nutshell, really that is what I would say in terms of not what the lawyer is expecting, but really about effective communication. As already pointed out, just know the different stages, know what answers to give and when, just to avoid clashing with lawyers. Because lawyers will usually have a field day. When they clash with the client, they throw you in disarray, and things like that. So the best is just to stick to what you are supposed to respond, stick to what you know. I think some doctors that have gone with to HPCZ, when we discussed, I think the first presenter talked about the pre-trial briefing. It's very important, because it is there that we'll go through. I'll tell you, these are the questions I'll ask. I would have gone through the medical file. I know what is there. This is what I'm expecting you to answer. If we have not talked about it, don't bring it up. Because the moment you bring it up, you open yourself up, and you are also going to throw your lawyer in disarray because they would not have prepared for that particular aspect. But sometimes it happens because people want to explain and explain, and in explaining, you go off tangent. So please, if you have a pre-trial briefing with your lawyer, stick to that pre-trial briefing. When you go to trial, when the lawyer is asking questions, stick to what you have discussed, stick to what you have written in your medical report. When it's cross-examination, just say yes or no. Yes or no. Whether you know that the answer is just say yes or no. The lawyer is listening. That's their job. They'll come and give you an opportunity to explain yourself in re-examination. You know, even lawyers, there's this rule that they'll always tell us to say, you should never ask questions that you never know the answer to. Reasons is simple. If a client is going to answer and you didn't know how they are going to answer, sometimes it may not be in your favor. I always laugh about this joke about this lawyer who was in court. It was a criminal matter. He's representing this client because some clients sometimes also can be misleading. And I think the client had been charged for murder or something like that. And for the prosecution, I think their major argument was that they had found very old tropicals at the scene where this person had died. And you know, with tropicals, when you wear them for a long time, they can actually follow the shape of your foot. Huh? So if anyone else wears them, you know that this is not the owner. But if the owner wears, you will know that it's the owner because the tropical would have had the shape. So the prosecution's argument was that tropicals were found at the scene, and these tropicals actually belong to this accused. So the lawyer who was representing the accused, when it was time for them now to take their witness on the stand, one of the things they requested the court was to ask for permission to allow their client to try the tropicals. And the court agreed. So the accused was given an opportunity to try the tropicals. And when he put his leg in there, even when the tropicals were old, nobody was told that these tropicals belong to this person because they fitted exactly. And unfortunately, the lawyer couldn't even continue asking questions. He just said, no further questions, my lord. And it ended there. So that is why when you are in court as lawyers, even as we are advised not to do things that we have not prepared, because you end up being surprised in court. So because the client had told the lawyer, and unfortunately clients do that, they had told the lawyer that I've never worn tropicals in my life. Those tropicals are not mine. The lawyer believed. So when he was telling the client to try the tropicals, in his mind, this person has never worn tropicals before. So these people are lying. But when the person tried them, just to find it was exactly his feet. Yeah. So the same way, even for you, when you go as a witness, stick to what you did. If the other person is going to ask you anything that you didn't do, just say, I'm not able to answer. I didn't do it. Full stop. The moment you try to explain if you didn't do it, you might open yourself up to other questions that can be used to attack you. So I think when it comes to what we expect or what I would expect from a client, doctor client, I think for me, that is what I would say. Understand why you are there. Let's have a pre-trial briefing. Stick to what we've discussed. Stick to your report. Know what questions, how you answer for all the 3 stages. Then the other person won't antagonize you. So there is no need to be apprehensive because you are not on, it's not you on trial. You are merely there to give a legal opinion, which at the end of the day is going to assist the court. And that is why sometimes they'll say that the medical legal opinion is merely of persuasive nature. It doesn't mean just because you've said it, then the court will take it. No, because there are so many other aspects. When there is a case, there are so many other aspects that are involved. The other witnesses will come to talk about those aspects. So though yours is merely to look at the medical aspect, this is my opinion, and I arrived at this particular conclusion. If it's a murder charge, what I found is consistent with the charge that has been meted on this person. But yours is not to say it is actually this person because you do not know. Yeah, if it's rape, if they say there was semen, you don't know if this semen is actually for this person or if somebody. So you will only be saying, when I did my examination, I found semen. And from the other findings I found, they are consistent with what? With the charge of rape. So you are not pointing that it is you, but you are merely saying, based on what I did, based on my medical experience, based on if there are any protocols you needed to follow and medical practice and whatever, this was my conclusion. Full stop. And no one is going to, because you are the expert in that particular aspect. So really, I think that's all I can say in relation to that particular topic, unless there are any questions that people would want to ask, or if there are any encounters that we have had and we did not know, how to do with it, we are free to do so. Thank you.
Thank you very much, Counsel, for that elaborate presentation. Despite you being first having challenges with the network and being stuck in traffic, we really appreciate as members of the Zambia Medical Association.
Thank you so much.
Okay, so at this point, ladies and gentlemen, we have come to the plenary session. So as earlier guided, this is going to be done a bit differently. This is not a plenary session only for questions, but it's also for those members that have been to court before. We would want you to utilize this time to just share a few experiences that you've had in court, so that our members who have never been at least can learn something. So we'll be taking hands, I think, in the sets of 3. And then for those that may not be able to ask, you can just type down your questions. We'll be able to read the question through in the text box. So at this point, I think let's see if we have any hands. Okay, seems like we don't have any. I think there should be something in the chat box. Okay, so this is a question for Dr. Luchenga. It's from Dr. Yajanani Piri. Says, it reads, Dr. Luchenga, you have mentioned the re-examination is for clarification. Can you then bring out information that you may have forgotten to bring up in the examination in chief? So that's the question for Dr. Luchenga.
Okay. Can I address that now?
Yes, you can go ahead, sir.
Okay, so in re-examination, from what I've learned and from what I know is that you cannot introduce new information. So you cannot bring about things that you forgot. And this is why the pre-trial, I think the previous speakers mentioned that the pre-trial is important. So you cannot literally say, I forgot this, and then you are introducing new information during the re-examination. No, you cannot do that. Thank you.
Thank you. Counsel, do you want to add?
No, I think what he is saying is actually what it is. Re-examination is merely for your lawyer to fill up the gaps, if at all there were any that were created in cross-examination. So you can't introduce anything new. He's merely asking you to clarify where he thinks you needed to explain. Yeah, thank you.
Thank you. So there are 2 hands. We'll start with Dr. Paul Kambe. Dr. Paul Kambe, you can go ahead.
Thank you, Chair. Counsel, I have one question. Is it possible, or what's your take on a colleague, or maybe standing in for a colleague who might be, maybe a colleague is unwell? Is it possible to stand on behalf of that colleague in court? I submit.
Okay, thank you.
Dr. Stella, you can go ahead.
Thank you
Dr.
so much.
Stella
Thank you. Good evening, and thank you so much, Counsel, for the presentation. Sorry, I just picked the presentation towards the end, but I wanted to share an experience and also ask a question based on that experience. I once went to court when I was working in Chingola as a senior resident medical officer as a witness concerning an issue of a defilement. So during, I don't know if you can call it cross-examination, they asked the person who was accused to ask any questions that he had, and then he asked and said, so, but doctor, are you saying that I'm the one who raped this child? So how would you answer such a question? Because you said we're supposed to just state a yes or no. And like what's the best way to approach such a question from, you know, the accused? And you know that, I mean, you can't give a definite answer, like you said, Counsel, that if you saw semen as you were examining or there's evidence that there was rape, you can't say, yes, you are the one. So what's the best way to approach that question? Thank you so much.
Thank you, Dr. Imabala. We can take the last question from Dr. Zulu. Dr. Zulu, you can go ahead.
Thank you so much. Am I audible?
Yes.
Okay. I think mine is more of a contribution. Thank you so much for the presentation. It's a beautiful presentation. I joined in late. I don't know if it has been handled on the issue of dress code for doctors when you're appearing in court. I think let's remember to dress properly. No crazy colors. You see that lawyers dress, they dress properly. You can able to tell this is a lawyer. So even for doctors, please avoid the crazy colors. You need to have dull colors so that we represent our profession very well. Thank you so much. I submit.
Thank you very much. Counsel, Dr. Mucheleng'anga, I think we can start by responding to Dr. Kambe's question. I think, Counsel, you can go first.
Which one is that? The one on the whether you can appear for a colleague?
Yes.
All right. Okay. Now, I think what is important to note is that courts are courts of fact. Okay, because what the court does not want to do is to send an innocent person to jail. So they always insist that when you bring witnesses or anybody is coming to speak in court, they must be witnesses of fact. Who is a witness of fact? They are witnesses of fact. For example, if it's a doctors, they are the ones who examined the person. So in the scenario of doctors, for example, if you are a junior and you have a senior, your senior cannot come and stand in your place to say, no, because I'm the senior in this department, I'm going to testify, because they are not a witness of fact. Everything they will be saying, it would be something they would have been told by the junior doctor. So the courts, the moment the other lawyers know that you are speaking in the capacity of what we call hearsay, meaning you were just told, you will find the other lawyer will object and say, you know, that's hearsay. So court is a court of fact. When you are speaking, that's why it's either, I was saying, when I was giving examples, I was saying it's either, you know, you would have witnessed something. When you witness something, you will still be speaking as a witness of fact because you are speaking to what you have seen. Doctors, when you are called to go in court in whatever capacity, whether it's rape or whatever it is, it will always be the one who did the actual examination, or unless when the examination was being done, you were in the room, such that when you are speaking, you are saying, I saw this person do this. I saw. You cannot go and say, so and so told me that this is what happened. So with that response, it will not be possible if the person who did say, for example, the examination is not well, you as the supervisor or any other colleague will not be in a position to go and stand in for them. And even the lawyers that have called you will be able to advise you. So the court only deals with the witnesses of fact and not any other. There are exceptions when hearsay might be acceptable, but even those have rules. But ordinarily, the general rule is it's always a witness of fact. So no, you cannot. On the second question, I think the doctor was asking now, this accused person comes and says, are you saying I'm the one who raped? Remember, I think when I was explaining, I mentioned to say, when you are going to court, yours is that you are merely giving medical opinion about a particular issue. You are not going there to prove whether a particular person is innocent or they are not innocent. That is why when I was giving an example of semen, you would have found semen. You will not be saying, I found semen which belongs to Peter. No, because you don't know. unless you have done, I'm sure maybe in the medical circles, there could be other tests that you do to establish if this particular semen actually belongs to this particular person. But if you have not done it, you end at, this is what I found. But you will not be able to answer the question of, this particular semen belongs to Peter. So if this person says, doctor, are you saying I'm the one who raped? For you, you can just say no. Because right from the beginning, yours is not to point this person that it's you. Because you don't know. Unless you went a further mile to try and establish that what I found actually belongs to him. But if you did not, yours is merely guide the court. If assuming in that situation they are still following the strict rules of trial, which usually is the case when it's just lawyers, your lawyer will be able to come in and say, you were asked if what you found, you are saying that this person, why did you say that? You'll be able to explain. All I was saying was that to try and avoid being put in an awkward situation where the lawyer antagonizes you, because the moment you put yourself in, the lawyer will go to the field and say all sorts of things and you will lose your line of thought. So to try and avoid that, just stick to the rules. For re-examination, it's just yes or no. There are some lawyers that are good, they will allow you to say, explain no, because this, because that, because this, but because you don't know the other person, lawyer you are going to meet on the other side, I would always advise my client, stick to the way you are supposed to answer in re-examination. Even the court knows that your role as a doctor is not to prove whether this particular person is guilty or not. So even if you say no, they understand. Remember, I've already said yours, you are merely assisting to give an opinion. Yeah. Thank you. I think that's all I can say for that particular one.
Thank you very much. So we'll take the second round of questions. I think we'll start with the chat box. I think this will be for Dr. Mucheleng'anga. How should the surgeon proceed when called to testify as a witness in a glossioma case in which the hospital is being sued due to issue of conflict of interest? This question is coming from Dr. Kalume Mayombo. And then we can take a second question from Dr. Anne Osinkala. Dr. Sinkala, you can go ahead.
Thank you, Dr. Sichula. Thank you for your presentations, Dr. Mucheleng'anga, and from the Council. Perhaps they could just comment on at what level can a doctor be summoned to go and be a witness in court? Is it a GRMO? Is it an SRMO? Because we've heard a lot of hearsays around that. So I'm just an intern, so therefore, even when I am summoned, the consultant is the one who's going to answer on my behalf. Then, because she touched something about being in the examination room, if you are the general practitioner who's on call and you attend to a rape victim, is your testimony still valid in a court of law, or should you always wait for a qualified obstetrician to come and do the examination for it to be valid testimony in a court of law? Thanks.
Thank you very much, Dr. Sinkala. We will take the last question from Dr. Should be, I think, Prince.
Yes.
You can go ahead, Dr. Prince.
Yes, please. Am I audible?
Yes, you are very audible.
Okay, thank you very much, Dr. Sichula, and thank you to our presenters. I'm trying to just share an experience. You know, during my time as head of casualty and emergencies at Casualty UTH there, court has been like my home. I've been going to court almost every week. And Dr. Mucheleng'anga can testify to that because I've been consulting him sometime. And yeah, so what happened, I recall one of the cases, and thank God I had the privilege of meeting very prominent lawyers like these Chanda, the Shimba. I've been in those courts. And here I'm going to talk about a case in Kabwe Court where I went. Then there was just a small problem about a stamp on the medical. So what happened, it's like the lawyer who was there by then, it was may he so rest in peace, who's that? Tutu Angulube. Yeah, he almost made the case dismissed because of the date stamp. You know, at casualty, when you see a patient inside the curtain there, and this patient, after you sign everything, the medicals, they go outside by the main reception there so that they get their paper stamped, okay? Then the stamp was on a wrong date. And me, I didn't know, because when I see the patient walks out of my place, and I don't know what is happening after that. So when the paper went to the court, they just found that when we're now in this cross-examination, I think Tutu Angulube knew already about that. And he was waiting because they were on the losing side. Then he just said, oh, it was funny, the same way the counsel said it. He just said, huh, can you tell us again your name? Who are you? I repeated my name. Then he said, it's shameful, Your Honor. This so-called doctor here can come from Lusaka up to Kabwe here to come and lie. He's hitting the money for the taxpayers, whatever. So it was a bit funny. And when he showed me the paper, he said, are you sure you are the one who signed this paper? I said, yes, it's me. Then I looked at it. Which date did you see this patient? You told us this and that. I said, oh, thank God, since I was like, you know, me, I pay attention to details, and I knew what was there. And my competence just helped me to say, oh, I see. And I went through and explained to him everything. And this is how that case was like maintained. And the aggrieved part was like, you know, benefited something from that. So my appeal here, it's each time we do this thing, especially when we are about to sign this police report, make sure in court, they don't joke about evidence. It's evidence. What is written? What are they seeing? You can't go there with stories and what. Just make sure even your papers, when you are signing, don't get it for granted. Check the date, what is written, the signature, how it is. And this is what I wanted to say, to share with you guys. And yeah, I think that.
Thank you very much, Dr. Prince, for sharing that experience. I think most of us are learning from that. And please, doctors, feel free. This is a webinar for you. I think we want those experiences to come out. I think we can only learn from experiences. So please, this is a very good platform for us. So for those two questions, the first one came from Dr. Nyirenda. Dr. Mucheleng'anga, over to you. The first question on the case of where as a doctor, you're called, as a surgeon, you're called to go and testify in a case where, say, an abdominal swab was left in a patient's body.
Okay.
Do you
No,
go
thank you
ahead,
very much.
or is there a conflict of interest?
Yes, so I'll go ahead. I wanted to address just one question that is it's been in the chat box for a bit. So it says during cross-examination, when you ask a yes or no to a question such as, have you ever lied before? What is the best way to answer? So I must say, Dr. Emilio Piri, that I've been told that before in court. I think a year ago, where a defense lawyer just said, have you ever lied before? And my answer is no. Full stop. If you've lied before, you should say, yes, I've lied before. But my point is, you should. And in saying this, I mean, the way we conduct ourselves, we should never be telling untruths in courts, no matter how uncomfortable it is. So the question is specific, have you ever lied before court? No, I've never lied before court. Full stop. So that's how I'd answer that question. I would say no, because I've never lied before in court, because that's perjury. And you can be sentenced, you can be imprisoned for that. So it's a criminal offense. So that is the answer to you, Dr. Emilio Piri. Next thing, I'll briefly comment about Dr. Prince, who is a dear friend of mine. So the way the way I tackle these kind of situations is during examination in chief. If you have reviewed your documentation during pre-trial, you should be able to pick up these things. When you pick up these things that there's a mistake or there is a date that is different, you must endeavor at all times to anticipate cross-examination questions and address them before they even occur in cross-examination. So what I do personally from experience is I look for the weak points in my examination. In fact, I ask the lawyer or the state advocate, who normally calls me, or the defense lawyer has called me, to cross-examine me themselves. That way, we try to anticipate the questions that may be asked so that I can clarify those things in my examination in chief. Most of the time, because there will always be commas, full stops that are in the wrong place, and or the name is misspelled or things like that. You have to clarify them before, so that even when the question is coming, it's coming with less venom or less sarcasm. So the second question that was asked before I go to the first one is, at what level can a doctor be summoned? So there is, in the case of Chidakwa versus the people versus Chidakwa in Chipata, it was held that, I think I was reading a judgment which said that the court we will read the medical reports. So the court can read the medical report and admit it, or they can call a witness to come and testify. The person who signed it should come and testify. So whether you're an intern, a GMO, or a consultant, if you are the person who goes to testify is the person who has signed the medical.
That's true.
So if you are the one who has signed the medical, you go and testify because you're the person. I think legal counsel touched on that. So I think that would be that's what has been my observation, that the person who has signed, who actually has examined the patient and has signed, is the one who goes to court. So court is, the way we reason in medicine is not the way the court reasons, and those are not the practices of the law. They are two very different dimensions of philosophy and thought, and even our epistemology is very different between the law and medicine. And so our administrative structure in hospitals must never be, that administrative structure must never be taken to court. I'm the supervisor, so I'm the one that is representing this one because this one is junior. No, the person who signs must go to court and testify. I think legal counsel has touched on this. Then the first one, the surgeon who left a hospital swab, and then should you go and testify? First of all, I'm trying to understand, where is the conflict of interest, right? Is this a government hospital? It's a private hospital. So the court can subpoena you. So when the court calls you, you don't have a choice. You can't say, I don't want to come and testify. So they can subpoena you. They've subpoenaed me before, especially defense counsels. When the prosecution doesn't call me, they always just subpoena me. And sometimes they subpoena you in cases that are, for example, in my case, they'll probably subpoena me in cases that are very state-driven. And because the prosecution didn't call me, the defense lawyer sometimes just calls and subpoenas. And I have to go. I can't say I'm employed by the government, so I cannot go and testify. No, because I cannot refuse a court summon. That's how I know it, and I think legal counsel may weigh into that. But that has been my experience. There's nothing about conflict of interest. It is a court summon. You should attend to it. Thank you. I think maybe counsel can come in on that one, the last one that I've just discussed here, to clarify.
Thank you, Dr. Mucheleng'anga. No, I think you've ably tackled all the questions, actually. And I was just going to add that on the issue where somebody has left a swab and the hospital is sued, I think for me, again, there, what I would want to say is that, what is management saying? Because if you are sued as a hospital, the question is, what is your position as a hospital? Because you must have one stance. You must have one stance on a particular issue. And if you feel that I think as a hospital here, we are wrong, there is nothing wrong in going to do amicable discussions. Yeah, it's not always that you have to go to court. So if the hospital you're working for has been sued, as Dr. Mucheleng'anga said, you don't have a choice, but you have to go. But I think what is important is that as a hospital, you must have discussed with management and taken a particular position. And this is a situation where you as a person, you feel, you feel contrary to whatever it is that management would want to take. But even then, it's collective responsibility. Yeah, and once subpoenaed, as Dr. Mucheleng'anga is saying, you don't have a choice. You don't have a choice. But otherwise, I think Dr. Mucheleng'anga has ably answered, I think, all the questions that I think were asked. I do not need to add or subtract anything from there.
Thank you very much, Counsel, and thank you very much, Dr. Mucheleng'anga. So due to the interest of time, I think this is almost 19:30, and we had promised that we would end the webinar at 19:30. So we'll take the last set of 3 questions. So I'll start with the chat box. The question, okay, so there's a question here, says, what is the penalty when a doctor does not show up in court when they have been called as a witness? So that is the first question. The next question, I will take a question from Dr. Michael Piri. Dr. Michael Piri, you can go ahead.
Hello, good evening. Can you hear me?
Yes, we can.
Yes,
okay.
we can.
Mine is a simple question. I remember I was in court for a murder case, and I was called to give my postmortem findings. Now, defense counsel, I think they had 4 legal aid guys who were defending the accused. And then they brought in evidence when the patient was first seen at the local clinic. Now, when they showed me the book, the usual clinic books that, they use at the clinic, what was done, so basically the defense counsel was asking me a yes or no question. And then when I read through the book, what was done, the presenting complaints were mostly, all of them were focused on trauma. The patient was complaining of general body weakness, headache, and stuff like that. And then there were no vitals, basically things were not done according to standards. There were no vitals. And then this patient ended up being given Coartem. There was no RDT, there was no investigation for malaria. There was no RDT, there was no slide. Of course, there was no RDT, right? And then they were put on Coartem. So defense counsel was like, do you agree, yes or no, that this patient had malaria? So when I said no, and then I wanted to justify my no, defense counsel, it became ballistic. No, I haven't asked you to start explaining yourself. It's a yes or no question. So how do you behave in such a manner? Because I didn't agree with what was done there, because the history and the treatment, and there was no evidence given that this person had malaria, but they were put on Coartem and some paracetamol. So I didn't agree with what was done by the practitioner at the local clinic. So how do you go about that in the case that even the lawyer that called you in re-examination does not even give you a chance to explain yourself? How do you go about that, especially when the defense lawyer now starts telling you, I didn't tell you to start explaining yourself, it's a yes or no question? And then another quick one is just on logistics. What is NPA doing in terms of logistics? Because especially Dr. Luchenga, I think maybe might help. What is NPA doing to raise the rates? Because I think they're still using outdated rates. And then sometimes you find that maybe you've been moved from one province to another, then you have to go and testify, let's say, Northern Province. This case I was in Lusaka, I had to go to Kasama. And then whatever NPA was offering wasn't adding up. The transport wasn't adding up because they don't use the government DSA. The transport wasn't adding up, the meal and the lodging wasn't adding up. So what is NPA doing to make sure that those things are addressed? Because I almost became a hostile witness because I had to be, I think they did a second call out because I couldn't go because of the money issues. So those are basically my 2 questions. I thank you.
Thank you very much, Dr. Piri. And we'll take the last question from Dr. Christopher. Dr. Christopher, you can go ahead.
Thank you so much. Great presentation. My question is from the experts. how do you deal with this situation where maybe especially from level 1 hospitals, where a different person sees a patient or examines the patient, and then maybe you just have this instruction from your superiors to just sign a medical report? Because from the presentation, we've heard that you're supposed to explain the whole process, how it began, the findings, what you did, and the like. So there's somebody who has seen the patient, who has examined, and then for you, you've received an instruction to just sign that medical report. How do you present yourself? Thank you.
Thank you very much. I think we'll start with Dr. Mucheleng'anga. You can go ahead, Dr. Mucheleng'anga.
Thank you. Thank you for the questions. Now, as usual, I'll begin with the last one. You cannot sign a medical report for someone you have not examined. I think that is clear. And when you do that, it jeopardizes the administration of the criminal justice system. So we should not do that. I think that there should be education towards that very end. We would not sign medical reports that we did of patients we did not examine. That's clear. The second one is NPA rates. I'll be very honest with you, Doc. Yes, I deal with NPA a lot, and I understand that now they're in the process of revising their rates. That's all I know, and that's what I'll speak to. So yes, they are in the process of revising their rates. However, a court summon, you must endeavor to answer. There are penalties. I think that legal counsel talked about you not showing up in court. So they are, I think, revising that. I think the last time I got that. Then the first question, where a person is seen and someone has asked you a question about malaria and you're trying to explain and they tell you don't explain. I think that I think legal counsel alluded to this area on everything that you need to explain will be explained in re-examination. So don't belabor the point. Your answer is, unfortunately, for us as medical doctors, we like to explain a lot of things, but the court has got rules. Cross-examination is, you had your time in examination in chief to explain everything. You're at large. That relates to the case. So when you are asked in cross-examination, it's a yes and no situation. And I always say, and there are times when I'm asked very, very tricky questions, and I say that answer does not have a yes and no. No, yes and no. I just said that answer does not have a yes and no. I can't answer yes or no because I'll mislead the court. And that's all. But that signals to the person, to the lawyer that has called me, that they need to probe that point further with me so that I can explain. So, but my feeling around that is, first of all, stick to why you've been called. You were called to discuss the postmortem report. Whether what they did for the patient at the clinic was right or wrong is not the question that you're answering. For us, is we don't volunteer information. I think this is what counsel and myself haven't said. We don't volunteer information in court. So we don't go answering questions that have not been asked. And when you're asked whether what was done at the hospital was right or wrong, we don't even opine on that, because we are here to speak to a postmortem report, especially in your case. You are there to speak to a postmortem report. I think the best was to say, I did not review. When you are doing the postmortem, sometimes they don't give you the records from level 1 hospitals, and it has happened to us a lot of times. And we are just very honest that we did not review. When you did not review a medical record before you are doing your postmortem, especially in your case, you state that you did not review. And then if you are asked on anything, whether anything is procedurally wrong, even if you know that it's procedurally wrong, you can't volunteer that information because it's immaterial to why you have been called as a witness. So stick to why. I think counsel be labor to teach us this point and labor to explain. Let us stick to why we've been called. And so what happened, whether it's correct or not, you don't agree with them, that is not what is before the court. The question before the court is in the case of murder. And there are things that they will determine based on many other witnesses. So it doesn't mean, most of the times, the reason we get we feel terrible during cross-examination is that we feel in our heads, we feel it's a murder. And believe me, I've been to court over 100 times, and all my cases are murder cases. Now, we don't go to court with the idea that, no, that one was not murdered, that one was murdered. No. We don't take upon us that kind of attitude. We go to court to explain what we saw to the court, what we don't know, what we didn't see. We tell the court we didn't see. If the prosecution lawyer doesn't ask further questions, it is up to them. Let us not. We do not get involved in the adjudication process. We are just there to give what we know, to say what we know. Thank you very much.
Thank you very much. I think the questions have been amply answered. Maybe just this last one, where someone was asking what happens if they do not go. And though I think this was also explained by Dr. Mucheleng'anga to say, when you are subpoenaed, we should always remember, especially when it's criminal matters, it's always the people versus whoever. So the people, it's basically the state. So when you are subpoenaed to go and appear as a witness in court, when you are saying no, other than the court, you are also refusing because it's the state against. So that's why you will hear sometimes they'll say they've issued a bench warrant. You can be arrested. So you will find yourself being inconvenienced more than if you had just gone there. But then again, if somebody had invited you to go to court, my assumption would be that if you are not able to go, you must liaise with the lawyer and explain why you are not able to make yourself available so that the lawyer is able to answer and explain in court for the court to understand. But if you do not, really, you will find yourself in problems. Yeah, thank you. Sorry, I know this was not one of the questions. I was just looking at some of the questions in the chat, and I just wanted to answer this one. I think that was asking what type of cases. For those that don't know me, sorry, I've been sitting in a dark place. I think if you go through the ethics chair, in the event that you are sued for anything that you've done in the course of your employment, it's not anything personal or whatever, but they've sued you for negligence or they've taken you to HPCZ, I'm available to handle. But for HPCZ, let me clarify, because I know I've been contacted sometimes when the matter is still at the stage of investigation. Because what HPCZ does is that when they receive a complaint, first they'll investigate. They just don't move in to charge you, no. They'll investigate. And it will depend on what they find after the investigation. They may decide to charge you, they may decide not to charge you. When you've been charged, it is usually at that stage that I will come and go with you to HPCZ. When it is investigation, I may just advise. I will not come because at that stage, there's really nothing much for me to do. But if you are charged, then I'm with you all the way, until we go. Because usually HPCZ, when they give a date of hearing, the procedure that is followed is basically what is followed in court, where you are given an opportunity to tell your story. There will be cross-examination by your supervisors and all those things. Yeah, but we would have done our pre-trial and everything. So I'm available to do that. And even assuming you are sued to go to court, but as long as it's something to do with something that happened in the course of your employment, I would be available to handle that. But if it's something outside personal, then the two of us can speak. Thank you.
Thank you very much, Counsel, and thank you very much, Dr. Mucheleng'anga, for taking some time from your busy schedules to come and explain to us and teach us about this important topic in our practice. So at this point, ladies and gentlemen, I think due to the interest of time, obviously would have loved to take more questions and listen to experiences that most of our colleagues have had in court. So I think allow me now to give the speakers just a minute to say a few closing remarks before I hand over to the Vice President of the Zambia Medical Association to close this meeting. So we'll start with Dr. Mucheleng'anga. A few closing remarks, sir.
So first of all, thank you very much for having me. I think I've thoroughly learned a lot of things discussing the work that we do daily in our office. Grateful to the Zambia Medical Association and to all the participants for listening in and contributing. it has been an insightful webinar. Thank you.
Thank you very much, Counsel. Over to you.
Thank you so much. I think equally, it's really been an honor to come and speak to this group. I'm always happy to do whatever work is supposed to be done. And please, if in the event that you would want to get any more clarifications as regards how we work, I'm available. But thank you so much.
Thank you very much, ladies and gentlemen. At this point, allow me to hand over to my boss, the Zambia Medical Association Vice President, Dr. Bright Mackenzie, to give his closing remarks. Dr. Mackenzie.
Thank you, Dr. Sichula. I hope I'm very audible.
You are, sir.
Thank you so much. So mine really is to thank our presenters, Dr. Mucheleng'anga and Madam Elizabeth Chanda. I think this was it was educative, and we thank you as Dr. Sichula for organizing such a meeting. I think we need such webinars more often so that our members are enlightened. So thank you so much to the presenters. And then my last thank yous goes to the members of the Zambia Medical Association. I know you took time to attend to this webinar out of your busy schedules. We can't take that lightly. We want to say thank you so much, and we wish you a very good evening. Thank you so much. Bye-bye.
Thank you very much, and you have a lovely evening. Bye.
Thank you. Bye-bye.
Thank you.
Thank you.
Thank you so much.
Thank you.
Thank you. Bye-bye.
Bye-bye.
Thank you.
Thank you. Bye.